Hello everyone, I am going to dictate the legal passage at the speed of 120 WPM. So be ready for the dictation. Start. Order 20 Rule 18 envisage passing of a decree for partition of property or for separate possession of a share therein. Full stop. Sub rule within bracket 2 bracket close is material which provides that if and insofar as such decree relates to any other immovable property or to movable property, the court may, if the partition or separation cannot be conveniently made without further inquiry, pass a preliminary decree declaring the rights of the several parties interested in the property and giving such further directions as may be required. Full stop. Thus, it could be seen that where the decree relates to any immovable property and the partition or separation cannot be conveniently made without further inquiry, then the court is required to pass an preliminary decree declaring the rights of several parties interested in the property. Full stop. The court is also empowered to give such further directions as may be required in this behalf. A preliminary decree in a partition action, is a step in the suit which continues until the final decree is passed. Full stop. In a suit for partition by a co-partner or co-sharer, the court should not give decree only for the plaintiff's share, it should consider shares of all the heirs after making them parties and then to pass a preliminary decree. Full stop. The words declaring the rights of the several parties interested in the property in sub rule within bracket 2 bracket close would indicate that shares of the parties, other than the plaintiffs have to be taken into account while passing preliminary decree. Full stop. Therefore, preliminary decree for partition is only a declaration of the rights of the parties and the shares they have in the joint family or co-personal property, which is the subject matter of the suit. Full stop. The final decree should specify the division by metes and bounds and it needs to be engrossed on stamped paper. Full stop. Para. The preliminary decree, in these appeals declared that the properties belong to the joint family of the plaintiffs and defendant number 1 set out in schedules A and B. Full stop. The details of the properties have been enumerated and they are liable to partition as per the right of the parties mentioned in the preliminary decree. Full stop. In other words, Chandrakant has 1/6 share and the appellants have 5th share. Full stop. The former is directed to pay certain sum towards marriage expenses of his sisters with a charge on the property allotted to his share. Full stop. He is also entitled to mention profits from the date of the institution of the suit in respect of certain properties specified in para 7 of the preliminary decree. Full stop. A commissioner was directed to be appointed to partition the properties mentioned in paragraph 8 of the decree. Full stop. Para 9 declares certain charges in respect of specified properties. Full stop. It would, thus, he seen that except declaration of the rights of the parties and the charge on the shares, there is no final decree. Full stop. The partition is to be effected by the commissioner to be appointed and as per directions from the court in that behalf. A preliminary decree in respect of 1/6 share of the first respondent was engrossed on the stamped papers submitted by him. Full stop. The question is whether the decree then became final and the rights of the parties stood crystallized as envisaged under section 2 within bracket 2 bracket close of CPC and, if so, when the limitation would begin to run for execution thereof. Question mark. Para. It is seen that the single judge of the High Court held that the limitation began to run from the date when the direction was given by the civil court to pass the final decree, and since the application was not made by the appellants within 3 years from the date, the application for execution stood barred, full stop. The single judge concluded thus, I, therefore, hold that limitation for executing a final decree in a suit for partition starts on the date on which the final decree is passed, that is, on the date on which the judgment directing the final decree to be drawn is given, and not from any subsequent date on which the parties supplies the non judicial stamp for engrossing the final decree, and when the court engrosses the final decree on the stamp and signs it, full stop, over.